Hello. This message is brought to you by the Contra Costa County Bar Association's Lawyer Referral Information Service. I am a lawyer in the San Francisco Bay Area, practicing in the area of family law. I'm here to tell you about some common issues and decisions you may face if you are involved in a family law dispute. Many people are faced with tough decisions to make at difficult times in their lives. Whether they are facing a possible divorce or separation, are having issues with another parent of a child or children, or fear for their safety due to someone's actions, the best possible way to evaluate their specific situation is to receive advice from a competent attorney who works in that particular field. The Contra Costa County Bar Association's Lawyer Referral and Information Service provides a panel of pre-approved and highly qualified lawyers who do just that, provide information based on their knowledge of the law and the legal system, geared at helping individuals explore their rights and choose a path to pursue them. In California, while it may be easy to get married, it's often not nearly as simple to get divorced. There are many requirements in the law, known as the Family Code, which both parties must comply with in order to get a divorce. California is considered a community property state. Generally, that means that all assets and debts that are acquired between the date of marriage and the date of separation are considered community property. In other words, they belong equally to each spouse. Generally excluded from this concept are gifts and inheritances of either party, assuming that party can prove with documentation the source of the gift or inheritance. Assets and debts that are commonly divided in a divorce proceeding include real estate, money and accounts, including investment accounts, contributions to retirement accounts made during the marriage, furniture, furnishings, vehicles, credit card debt, and other revolving debt. The valuation and division of a community estate can be an area of conflict and disagreement between the parties. During a consultation with a lawyer, you can learn what options are available in this area and the different requirements necessary to establish a legally valid position. If there are children from the marriage, the court has the authority to make orders regarding these children, generally until the children turn 18. The courts are guided by a policy that obligates them to make decisions that are in the children's best interests. If you and the other parent are unable to agree on what's in the children's best interests, it may be necessary to appear before a judge who will make the decision on behalf of the children. If the parties were never married, but do have children in common, they will not seek a dissolution or divorce action, but rather a paternity action. Once paternity is established, and if the parents are still unable to come to an agreement regarding what's in their children's best interest, the courts will still be guided by the same policy and make an order on behalf of the parents. Support is often an issue in a divorce proceeding. Generally, if one party earns more than the other party, and the lower earning party has a need for support, the court is authorized to make an award of support. Spousal support, or alimony as it's otherwise known, is generally a tax-deductible payment by the party paying support and taxable to the party receiving the support. If there are children between the parties, whether during a divorce proceeding, a proceeding for legal separation, or for paternity, the court has the authority to make an order of child support based upon a legislatively created formula. While the formula is complicated, the lawyers on the Lawyer Referral and Information Service have the knowledge and experience to help determine the general parameters around the issue of child support. In addition to child support, the Family Code provides that the parents will typically share child care costs to allow either parent to work or go to school, as well as any out-of-pocket medical expenses incurred for the children. In certain cases, there may be a need to protect the safety of one party from another, whether the parties are married or not. The LRIS panelist lawyers can help individuals figure out whether their needs rise to the level of domestic violence as set forth in the Family Code, and can help them seek an order that appropriately protects them and potentially the children. Finally, if you've been served with court papers, you must act within certain time frames in order to protect your legal rights. waiting to act or file appropriate responsive paperwork could have serious consequences, both personally and financially. Information is empowering. By consulting with a competent lawyer, you can get the necessary information to evaluate your situation, know your rights, and know how to protect them. In your area, there should be a Lawyer Referral and Information Service, sponsored by the local bar association. You can usually find the service in the Yellow Pages or go on the internet. The Contra Costa County Bar Association's Lawyer Referral and Information Service in the San Francisco Bay Area can help you find answers to legal problems by giving you an initial consultation with a lawyer near you at a very low cost. The lawyer can explain the specifics of the law in your case and can answer all of your questions in detail.